Hello and welcome. This is U.S. copyright attorney Eric Kelly. In this video, I'll be explaining the legal concepts around U.S. copyright fair use. I wanted to make this video because copyright fair use is so widely misunderstood, overused, often abused, and often relied on improperly. And I see a lot of fellow YouTubers who often use the creative works of others without permission, such as reaction YouTubers and YouTubers who do reviews and others, and often what they are doing does not fall into copyright fair use in my opinion. So I think this is an important and relevant topic to address. Alright, let's get into this one. So first, one should understand that as a general legal principle, there are in fact different types of fair use. There is fair use in the context of copyright infringement, and there are types of fair use in the context of trademark infringement. For example, when a restaurant includes a trademark of Coke or Pepsi on the given restaurant menu, that is often an example of a type of trademark fair use. However, the focus of this particular video will be on fair use with respect to U.S. copyright law. The legal doctrine of U.S. copyright fair use stems from a U.S. federal law, in particular a U.S. federal statute, which is Title 17 of the United States Code, Section 107, which is what you're seeing a screenshot of here on the screen, and all the various U.S. federal court cases that have interpreted that particular statute according to the facts of those cases. Before I get into the meat of that statute, that is, before I discuss the substantive aspects of that statute, I'll discuss at least some of the procedural aspects of this law of copyright fair use, and then we'll return and get back into the meat, the substantive aspects of this law of U.S. copyright fair use. By procedural aspects of U.S. copyright fair use, I'm referring, at least in general, to some of the timing and cost implications that are often ignored when people think about fair use. So first, it's important to understand that the legal doctrine of copyright fair use is an affirmative defense to the legal claim of copyright infringement. Because fair use is an affirmative defense, then the legal issue of fair use only becomes legally relevant after one has been sued for U.S. copyright infringement. When one is sued for U.S. copyright infringement, that's generally because the alleged infringer, which is generally the defendant, basically used someone else's creative work without their permission. So whenever someone uses someone else's creative work without permission, it's possible that they might get sued for U.S. copyright infringement. And if that happens, it's only then that the affirmative defense of fair use might even become relevant. Otherwise, it's not even relevant to discuss that fair use. So generally, the defendant, again, the alleged infringer, in a U.S. federal copyright infringement lawsuit would generally first raise the legal issue of fair use by pleading that particular affirmative defense of fair use in the defendant's first pleading, which is generally called the answer. Or possibly the issue of fair use could first be raised in what's called a motion to dismiss by that particular defendant. That fair use is an affirmative defense also generally means that a court, the judge and or the jury, would generally not address or go over the issue of fair use until after the plaintiff has concluded their case at trial. The plaintiff is generally going to be the owner of the copyright, and they're the one that's alleging that their copyright's been infringed. And trial is one of the very last stages of a lawsuit. So a court might not address the issue of fair use until very late in the case. Or sometimes in the alternative, the issue of fair use might not be raised in the case until there are what's called summary judgment motions, which again, or summary judgment motions generally occur after the discovery phase of the lawsuit. So again, the issue of fair use might not be raised or addressed in the particular case until rather late in the case. Or sometimes in the alternative, again, the issue of fair use might not be addressed until a motion on the pleadings is filed or a motion to dismiss is filed. But generally the point here is that generally the longer a case lasts, the longer the case takes, the more money that both parties are going to be paying in their own attorney fees. So as the defendant, even if you've raised the issue of fair use, that issue might not be decided till rather late in the case. And whether you prevail or lose on that defense of fair use, you will have paid lots and lots and lots of money, many thousands of dollars, in attorney fees just to get to that point in the case, whether you're going to win on that defense or not. Also note, because fair use is an affirmative defense, that means that the defendant has the burden of gathering and presenting evidence to support that defense of fair use. So it's also important to consider that even if you presented a defense of fair use, if you lose that defense and you've lost any other defenses you might have raised, if you're found liable, if one's found liable for U.S. copyright infringement, then you may be on the hook having to pay the plaintiff's attorney fees. You have to pay the other side's attorney's fees. That's not a guaranteed thing that always happens, but it's a possibility. And that can be very risky because the other side's attorney fees can be huge. Now, from the plaintiff's perspective, that is from the perspective of the owner of the copyright that might have been infringed, it's generally a good practice to assess the affirmative defense of fair use that a defendant might raise before the plaintiff were to file a DMCA takedown notice and or before plaintiff might file a U.S. federal copyright infringement lawsuit. If a plaintiff does those things, that can reduce the ability of the defendant to attack the plaintiff for failing to act in good faith. So those are some of the what I would call procedural issues behind copyright fair use, namely that because fair use is a defense, an affirmative defense of the defendant, it's generally going to come up late in the case, and it's generally, at least by that point in the case, that the defendant will have already spent many, many thousands of dollars in attorney fees. So that's important to consider if you're trying to rely on the defense of fair use. Okay, so let's return and now talk about kind of the substantive aspects of copyright fair use under this particular law. So that is, let's look at the meat of this particular law. So essentially the law says this: the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include: number 1, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Factor number 2, the nature of the copyrighted work. And the third factor says the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And factor number 4, the effect of the use upon the potential market for or value of the copyrighted work. And additionally, then part of the statute basically says that fair use could still be applicable to unpublished or non-published works. Ideally, you want to examine all 4 factors to your unique set of facts. No one factor is necessarily more important than the others. It just depends upon the given unique facts at hand. So sometimes under different fact scenarios, one particular factor might be more important, and then under a different fact scenario, a different factor might be more important. So it just varies depending upon the facts. And a small change in the facts can often lead to entirely different legal conclusions as to whether or not fair use is applicable or not. So basically you want to try to examine all 4 factors with your particular facts, and then you weigh all those factors together to try and arrive at whether or not fair use is supported by those facts or not. So from a substantive perspective of copyright fair use under this particular law under Section 107, we're going to now look at each one of these 4 factors by itself to get a little bit better feel for what's going on with each of these factors. Okay, so with respect to the first factor, which was the purpose and character of the use, including whether such use is of commercial nature or is for non-profit educational purposes, basically, if the alleged infringing content, critiques, and or comments about the original work, that can often support a finding of fair use. That's why parody is often treated as fair use. Parody is generally when the alleged infringing content critiques, comments, or pokes fun at the original work. Whereas in contrast, satire often is not fair use, because with satire, the alleged infringing content is not critiquing, commenting, or poking fun at the original work. Rather, the alleged infringing work is merely misappropriating the original work to make fun of something else. Additionally, with respect to this first factor, if the alleged infringing content is something of like news reporting or teaching or scholarship or for research purposes, any of those or all of those typically support a finding of fair use, at least for that particular factor. If the alleged infringing content was for a nonprofit purpose and or for an educational purpose, that can also often support a finding of fair use for that particular factor, for this first factor. Often with this first factor, the parties and or the court will discuss whether or not the alleged infringing work was transformative as compared to the original work. So you'll often see that particular legal term, that buzzword, transformative. So for example, a parody is often treated as being transformative with respect to the original work. If the alleged infringing work was transformative or is transformative with respect to the original work, the work that's alleged to have been infringed, as it might occur with parody, criticism, commenting, news reporting, teaching, education, nonprofit scholarship, and or research, any or all of those can support a finding of fair use for this first factor. Whereas if the alleged infringing work was for a commercial use and or a commercial purpose, that may favor finding no fair use for this particular first factor. Note, YouTube videos, even non-monetized videos, could be treated as if the YouTube video was for a commercial use or commercial purpose, because an intent of most YouTube videos is to get watched, to get views, get likes, and or get subscribers, which are all kind of lean towards that having a commercial purpose or bent. Now, clearly a monetized video could often be treated as having a commercial purpose or commercial use. So that could be, for this particular factor, weighing against finding fair use. Okay, now let's look at the second factor, the nature of the copyrighted work. This second factor is often about assessing the strength or the weakness of the copyright in the given original work that has been alleged to have been infringed. Basically, you're kind of looking at how creative is that original work, or rather, on the flip side, how informational and non-creative was that original work. The more creative the given original work, the more likely that this second factor would favor not finding fair use for this particular second factor. That is, works that are considered to have strong copyrights are generally not going to favor finding fair use for this second factor. Whereas works that have weak or thin copyright, you could then argue would favor finding in favor of fair use for this particular factor. Also note that with whatever content you're talking about, if whatever facts, information, or data is within that content, copyright never protects facts, information, or data. So the more that a given creative work is full of facts, information, or data, then in general, you could argue that it has a thin or weak copyright, and then that might favor finding in favor of fair use for this particular factor. Okay, let's look at the third factor now in more detail. Again, the third factor was the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So essentially what this third factor is trying to assess whether or not the amount of the original work used in the alleged infringing content was no more than necessary for the purpose of the alleged infringing work identified under the first factor. So for example, if the alleged infringing work was identified under the first factor as being for the purpose of criticism or comment, then we're asking, was the amount used no more than necessary to achieve that purpose of commenting or critiquing? But in general, the less that is used of the original work, that tends to favor finding or being in support of fair use for this particular factor. Whereas the greater the amount used of the original work in the alleged infringing work tends to favor finding against fair use for this particular factor. But those are just general guidelines. So for example, there can be situations where you've used minimal amount of the original work, but that still favors finding no fair use because the little portion that was used was like the heart of the original work, sometimes referred to as the money part, or maybe the hook portion of a song. And sometimes in those situations, if only a little bit's used, but it's an important part that was used, that can favor finding against fair use for this particular factor. And there have been cases where the entire original work was used and the court still found that that whole use was fair use for this particular factor. However, I think those kind of cases are typically more rare. So I think as a general principle, if you're using the creative work of another, you likely should only use what's necessary to achieve that particular purpose under factor one. the purpose under factor 1 is something that is supportive of fair use, like critiquing or commenting on the original work. Okay, so now let's talk a little bit more in detail about the fourth and final factor. And again, the fourth factor was the effect of the use of the alleged infringing work upon the potential market for or the value of the original copyrighted work. So with the fourth factor, you kind of want to think about whether or not the alleged infringing work creates a substitute or a competitor to the original work. For example, if the alleged infringing work harms the potential market or value for the original work, that would favor finding no fair use for this fourth factor. Whereas if the alleged infringing work does not harm, or even maybe it helps the potential market or value for the original work, that could favor finding in support for fair use for this fourth factor. Whatever you're trying to argue for this fourth factor, it's important to present evidence that support that particular argument for this fourth factor. So sometimes you'll see with like reaction YouTubers that they might actually present the entire original work in their particular video. And in doing so, they might be basically creating a substitute or competitor to the original work. So under this factor, under that situation, that could weigh against finding fair use under this fourth factor. And going back to the third factor, which is kind of the amount used, that could, when the entire amount is basically used, in general, that's going to favor finding against fair use under the third factor as well. I think it's hard to analyze these four fair use factors outside of actual facts. Without actual facts, looking at these four fair use factors is kind of just an abstract exercise. I think the best way to get a feel for how the courts analyze these four fair use factors against real world facts is simply by reviewing the cases where the various U.S. federal courts have weighed in on these four fair use factors. So here's a particular link to a Copyright Office's website where they actually kind of summarize at least most of the U.S. federal court cases that have touched on fair use. And they look at it from all different kind of aspects. So this can be a very useful process to go through and look at some of these cases to actually get a feel for how the courts actually apply these four fair use factors to various different facts. So we'll go ahead and look at some of these cases now. Okay, so you're seeing a portion of the U.S. Copyright Office's website, and this is their U.S. Copyright Office Fair Use Index. And then you can see that it provides some information about what fair use is, kind of what we've just gone over. So here's the four factors that we've talked about. Then additionally, what you can do from here, you can click on this button here and actually search a summary of all the different cases that have touched on fair use and look at how the courts have decided those cases. Okay, so we'll go ahead and click the search index here. And so right now, everything's selected here. So basically all the cases are showing up here. And you can see most recent cases from 2022, Ninth Circuit. And, if you scroll down, it goes all the way back to 1841 as to being one of the very first fair use cases. And then over here in this far right column, it tells you whether fair use was found or not found. And then we'll go back up to the top. So in this portion here, you can actually select the different jurisdictions of U.S. federal courts that might be applicable to your situation, depending on where you're located in the country. Or you can look at all of them. And then for this area, this looks at the different topics that might have been relevant to that particular case. So for example, if we deselect all of them, you'll see all the cases go away, but maybe you're interested in how fair use is being applied to music cases. So you can look at just that. Or maybe like if you're a YouTuber, you'd be looking at basically audio visual, that's videos essentially, and you can look at that. And there's overlap. Sometimes there's overlap between these. So for example, here's a case that I've already looked up right here. And this says film or audio visual and music. So it touches on both. We'll look at this particular case because it touched on music basically from the artist Prince and also dealing with a YouTuber. So we'll click on the link and this will bring up a summary of that particular case. Okay, so now you can kind of see a summary of this particular case. So yeah, up in this portion, it tells you kind of the key facts, the issue that was being decided on this particular case, and then the holding or the courts, what the court basically said about these facts as applied to the law. And then you can see at the bottom the outcome that their fair use was not found. So under this particular facts, you had a YouTuber who was the defendant, and basically that YouTuber had gone to or obtained live recordings from a Prince concert and then basically uploaded those concerts, those live Prince concerts to his YouTube channel. Now, that YouTube channel did receive a DMCA takedown notices, so the content was initially removed. However, the YouTuber then responded with counter notifications claiming that the videos were fair use. And then the plaintiff, who's basically the estate on behalf of deceased Prince, basically sued the YouTuber for copyright infringement. And then the YouTuber tried to defend, trying to argue that his use of those Prince concert performances were fair use. And then in the holding here, it goes on to explain, according to those 4 factors, why this was not fair use. So, for example, with respect to the first factor, the defendant tried to argue that his shooting of those videos while at the concert was transformative, and basically the court rejected that argument because he didn't alter the music in any way. The second factor basically also did not favor fair use because the nature of the copyrighted work, which was basically the Prince concert, was highly creative. And so that second factor also was found not to support fair use. Now, with respect to the third factor, again, the court found that the third factor did not support fair use, essentially because the YouTuber used a lot of the Prince concert footage, and essentially he used what was considered to be the heart of those performances. And finally, the court, under the fourth factor, also found that the fourth factor did not support fair use, essentially because they felt that the YouTuber's videos were diverting traffic away from the authorized Prince YouTube channel, which basically deprived Prince's estate, of advertising revenue. So all 4 factors in this particular situation, you can see how the court applied the facts to all 4 factors, and each one of them weighed against finding fair use. Okay, let's go back and look at a second case just as another example. So we'll look at a strictly music case this time, and we'll look at this one, which is basically Tracy Chapman versus Nicki Minaj. Okay, so again, here's the summary of the case, the key facts, the issue, the holding, and you can look at the outcome here. Here they found that Nicki Minaj's use of a Tracy Chapman song was considered fair use, and they go through all the 4 factors here. So basically, Nicki Minaj redid Tracy Chapman's song called Sorry, but it was for the purpose of experimentation. So you can see here under the facts that Nicki Minaj knew that she needed to obtain a license to publish the remake of the song for basically public consumption, because her remake incorporated a large number of lyrics and vocal melodies from the original song. And Nicki Minaj made multiple requests to Tracy Chapman for a license, but Tracy Chapman denied all of those requests. And so essentially, at least according to the fact, Nicki Minaj never intended to release this song because, again, it was just for experimentation purposes. However, at some point, the Nicki Minaj version does get released out to the public, and it looks like it might have been an accident. And once that happened, that's when Tracy Chapman found out and basically started the copyright infringement lawsuit. So here you can see how the court applied the first factor to these particular facts, which is dealing with the purpose and character of the use, basically the Nicki Minaj use. And the court said that the Nicki Minaj use of this particular remade song favored fair use because basically the court concluded that Nicki Minaj's initial purpose of this song was experimentation. However, you can then see on the second factor, which deals with the nature of the copyrighted work, that this particular factor favored against finding fair use because the original song was a very creative work, which basically is the whole purpose of the copyright in the first place. So that favored against finding fair use. Interestingly, on the third factor, which deals about the amount of the original work that was used in the alleged infringing work, here Nicki Minaj used substantial amounts of the work, but the court still found that this particular amount favored fair use because Nicki Minaj only used basically what it says, no more than necessary, to show Tracy Chapman how Nicki Minaj intended to use Tracy's work in the new work. And then here you can see how the court addressed the fourth factor here. And the court basically said that there's no evidence that the Nicki Minaj version of the song basically creates a competitor or a substitute for the Tracy Chapman version of the song. And then so overall, looking at all four factors together, the court said that taken as a whole, these factors favor finding that Nicki Minaj's use of this Tracy Chapman song was fair use. So anyway, you can go through, all these different cases, or at least, a handful, or at least ones that might be particularly relevant to your particular situation. And you can look at how different courts have looked at the facts of those particular cases in relation to these four fair use factors. And that can give you a much better feel for how these four factors actually work out in the real world. Okay, to recap, we've looked at both some procedural issues and some substantive issues around U.S. copyright fair use law. From the kind of the procedural perspective, we looked at the timing and cost implications that follow from the fact that Title 17 of the United States Code, Section 107 on fair use is an affirmative defense. So particularly we looked at that fair use does not even come up legally until one is sued for copyright infringement, and the issue of fair use might not be decided by a court until rather late in the case, and because of those timing issues, a defendant would likely have already paid many thousands of dollars, at least in attorney fees by that time in the case. And substantively, we looked at each of these four fair use factors in detail, including looking at how some cases have applied the facts of those cases to the four fair use factors to get a better feel for how those four fair use factors actually work in relation to real world situations. And I definitely encourage you to look over the Copyright Office's Fair Use Index webpage and all of their cases that they've summarized so that you can continue to get a better feel for how those four fair use factors are actually applied to real world fact situations. There's probably no better option besides doing that to get a really good grounded feel for how this really works. Okay, this has been U.S. copyright attorney Eric Kelly. And I do work with clients from all over the world and all over the United States. I am a copyright attorney. I'm also a trademark and patent attorney. And copyrights are an intellectual property tool that deals with protecting creative work, things like photographs and videos and music, literary works and things of that nature. Whereas trademarks are an entirely different intellectual property tool, which are designed to protect branding. And lastly, we have patents, which again is another intellectual property tool, and patents are designed to protect novel and non-obvious inventions, essentially new products. And then lastly, you can see here some contact information if you wish to reach out to me regarding intellectual property matters. Thank you. Please like this video and subscribe to my channel to help me reach others about intellectual property matters. And here's some of my suggested videos on U.S. copyright issues. Thank you.